Motion. A formal written or oral request made by an attorney asking the court to issue a ruling, order, or take a specific action in a case, serving as the primary tool lawyers use to shape the boundaries, evidence, and procedure of litigation before and during trial. Moving party. The party who files and argues in favor of a motion, bearing the initial burden of presenting legal grounds and supporting arguments sufficient to convince the court to grant the requested relief. Non-moving party. The party opposing a motion who must respond with legal arguments and evidence demonstrating why the court should deny the relief requested by the moving party. Motion practice. The body of procedural rules, strategies, and tactics governing the filing, briefing, arguing, and resolution of motions throughout the life cycle of a case, from pre-trial through post-verdict proceedings. Brief. A written legal document submitted to the court by an attorney in support of or in opposition to a motion, setting out the relevant facts, applicable law, and arguments the attorney wants the court to consider. Memorandum of law. A document submitted alongside a motion that provides the legal authority, statutes, case law, and legal reasoning, supporting the moving party's position, sometimes called a memorandum of points and authorities. Opposition. The formal written response filed by the non-moving party arguing against a motion, presenting counter-arguments, distinguishing cited legal authority, and urging the court to deny the relief requested. Reply brief. A supplemental brief filed by the moving party in response to the opposition, addressing the arguments raised by the non-moving party and reinforcing the original grounds for the motion. Oral argument. A live hearing before the judge in which attorneys for both sides present their positions on a pending motion and answer questions from the court, providing an opportunity to clarify written arguments and respond to judicial concerns. Order. The court's formal written decision on a motion stating whether the motion is granted or denied and specifying any conditions, limitations, or actions required as a result of the ruling. Sua sponte. Latin for of its own accord, referring to a judge's decision to take an action or issue a ruling without being asked by either party, such as raising a legal issue or dismissing a case on grounds neither side raised. Ex parte. Latin for from one party, referring to a motion or communication made to the court by one party without the presence or prior notice of the opposing party, permitted only in emergency or limited circumstances. Motion to dismiss. A pre-trial motion asking the court to terminate the case entirely before it proceeds to trial, arguing that even accepting all of the plaintiff's allegations as true, there is no valid legal claim that entitles them to relief. Failure to state a claim. The most common ground for a motion to dismiss, asserting that the complaint does not allege sufficient facts to support a legally recognized cause of action, regardless of whether those facts are true. Lack of jurisdiction. A ground for dismissal asserting that the court does not have the legal authority to hear the case, either because it lacks subject matter jurisdiction over the type of dispute or personal jurisdiction over one of the parties. Improper venue. A ground for dismissal or transfer asserting that the case has been filed in the wrong geographic location and should be moved to a court where venue is properly established under the applicable rules. Motion to transfer. A request asking the court to move the case to a different court or jurisdiction, either because venue is improper or because another location would be significantly more convenient for the parties, witnesses, and interests of justice. Motion for a more definite statement. A motion asking the court to require the opposing party to clarify or elaborate on a vague or ambiguous pleading before the moving party is required to respond to it. Motion to strike. A motion asking the court to remove specific content from a pleading or other filing, such as irrelevant, redundant, impertinent, or scandalous material, that should not be part of the official record. Motion to consolidate. A request asking the court to combine two or more related cases into a single proceeding, typically filed when the cases share common questions of law or fact, and consolidation would promote efficiency and avoid inconsistent results. Motion to sever. A request asking the court to separate claims or parties that have been joined together in one lawsuit into distinct independent proceedings, typically when trying them together, would be prejudicial or confusing. Motion for extension of time. A request asking the court to grant additional time beyond a filing deadline, typically supported by a showing of good cause explaining why the extension is necessary and will not unfairly prejudice the opposing party. Motion to compel. A motion asking the court to order a party or witness who has failed or refused to comply with a discovery request to produce the requested documents, answer interrogatories, or appear for a deposition. Motion for protective order. A motion asking the court to limit or restrict certain discovery requests, typically to prevent disclosure of privileged, confidential, or disproportionately burdensome information that should not be subject to discovery. Motion to quash. A motion asking the court to invalidate a subpoena or other discovery demand, typically on grounds that it is overbroad, unduly burdensome, seeks privileged information, or was improperly issued. Sanctions. Penalties imposed by the court against a party or attorney for abusive litigation conduct, discovery violations, or failure to comply with court orders, ranging from monetary fines to adverse inference instructions or dismissal of the case. Adverse inference. A sanction or jury instruction permitting the fact finder to assume that evidence a party destroyed, concealed, or failed to preserve would have been unfavorable to that party if it had been produced. Spoliation. The destruction, alteration, concealment, or failure to preserve evidence that a party knew or should have known was relevant to pending or reasonably foreseeable litigation, potentially resulting in sanctions or adverse inference instructions. Motion for discovery sanctions. A motion asking the court to impose penalties against a party who has engaged in misconduct during the discovery process, including failing to produce documents, providing false answers, or violating protective orders. Motion for summary judgment. A motion asking the court to decide the case, or a specific claim within it, without a trial, arguing that there are no genuine disputes of material fact and the moving party is entitled to judgment as a matter of law based on the undisputed evidence. Genuine dispute of material fact. The standard that defeats a motion for summary judgment existing when a reasonable jury could reach different conclusions about a fact that is essential to the outcome of the case based on the evidence presented. Judgment as a matter of law. A ruling that the evidence is so overwhelmingly one-sided that no reasonable jury could find for the opposing party, entitling the moving party to a verdict without submitting the case to the jury. Motion for partial summary judgment. A motion seeking summary judgment on fewer than all of the claims or issues in the case, narrowing the issues that will need to be resolved at trial, even if the entire case cannot be decided without a jury. Motion to dismiss for failure to prosecute. A motion asking the court to terminate a case because the plaintiff has failed to move the litigation forward within a reasonable time, demonstrating a lack of diligence in pursuing their own claims. Default judgment. A judgment entered against a party who has failed to respond to a complaint or appear in the proceedings, effectively allowing the opposing party to win without a trial due to the defaulting party's failure to participate. Motion to set aside default. A motion asking the court to vacate a default judgment entered against a party, typically requiring a showing of good cause for the failure to respond and a meritorious defense to the underlying claims. Motion in limine. Latin for at the threshold, a pretrial motion asking the court to rule on the admissibility of specific evidence before trial begins, preventing that evidence from being mentioned in front of the jury until the court has determined whether it is legally permissible. Exclusionary motion. A motion in limine seeking to prevent the opposing party from introducing specific evidence at trial, arguing that its admission would be prejudicial, irrelevant, unreliable, or otherwise improper under the rules of evidence. Motion to admit. A motion in limine seeking a pretrial ruling confirming that specific evidence the moving party intends to introduce will be admissible at trial, providing certainty before opening statements begin. Limiting instruction. A judge's direction to the jury that certain evidence admitted at trial may only be considered for a specific limited purpose and not as proof of other matters, often used when evidence is admissible for one reason, but could be prejudicial if considered more broadly. Offer of proof. A brief presentation made outside the jury's presence in which an attorney explains what a witness would say or what evidence would show, allowing the judge to rule on admissibility without the jury being exposed to potentially inadmissible material. Prior bad acts. Evidence of a defendant's previous misconduct or criminal history that is generally inadmissible to show propensity to commit the charged offense, but may be admitted for limited purposes, such as showing intent, motive, identity, or absence of mistake. Character evidence. Evidence about a person's general traits or reputation, governed by strict rules that generally prohibit its use to prove conduct on a specific occasion, but allow it in certain circumstances, such as when the defendant introduces it first. Hearsay motion. A motion in limine seeking a pretrial ruling on whether a specific out-of-court statement falls within the definition of hearsay, and whether any exception applies that would permit its admission at trial. Expert qualification motion. A pretrial motion challenging whether a proposed expert witness possesses sufficient knowledge, skill, experience, training, or education to be qualified to offer expert opinions on a particular subject at trial. Daubert motion. A motion challenging the admissibility of expert testimony on the grounds that the expert's methodology is not sufficiently reliable or scientifically valid under the standard established by the Supreme Court in Daubert v. Merrill Dow Pharmaceuticals. Rape shield motion. A motion invoking rape shield laws to prevent the introduction of a sexual assault victim's prior sexual history or reputation at trial, with narrow exceptions for specific circumstances where such evidence may be constitutionally required. Motion to suppress. A motion asking the court to exclude specific evidence from trial on the grounds that it was obtained in violation of the defendant's constitutional rights, most commonly the Fourth Amendment's protection against unreasonable searches and seizures. Suppression hearing. An evidentiary hearing held outside the presence of the jury in which the court evaluates the circumstances under which evidence was obtained, allowing both sides to present witnesses and argument on whether suppression is warranted. Standing to suppress. The requirement that only a defendant whose own constitutional rights were violated may move to suppress evidence, preventing defendants from challenging searches that only affected third parties' rights. Fruit of the poisonous tree. The doctrine requiring suppression not only of evidence obtained through a constitutional violation, but also of all secondary evidence discovered as a direct result of that initial violation, unless an exception applies. Independent source doctrine. An exception to the exclusionary rule permitting the use of evidence that was discovered through a constitutional violation if the prosecution can demonstrate that the same evidence was also discovered through a separate lawful investigation independent of the violation. Inevitable discovery doctrine. An exception to the exclusionary rule allowing tainted evidence to be admitted if the prosecution can show that law enforcement would have inevitably discovered the evidence through lawful means even without the constitutional violation. Attenuation doctrine. An exception to the exclusionary rule permitting the use of evidence obtained following a constitutional violation when the connection between the violation and the discovery of the evidence has become so weakened by intervening events that suppression is no longer warranted. Good faith exception. An exception to the exclusionary rule allowing evidence obtained by law enforcement who reasonably and in good faith relied on a search warrant that was later found to be defective, recognizing that exclusion serves little deterrent purpose when officers acted honestly. Motion for directed verdict. A motion made during trial, after the opposing party has presented their evidence, asking the judge to rule that the evidence is legally insufficient to support a verdict in that party's favor, effectively ending the case before it goes to the jury. Motion for judgment, notwithstanding the verdict, JNOV. A post-verdict motion asking the judge to overturn the jury's verdict and enter judgment for the moving party, arguing that no reasonable jury could have reached the verdict rendered based on the evidence presented at trial. Motion for a new trial. A post-verdict motion asking the court to set aside the jury's verdict and conduct an entirely new trial, typically based on grounds such as jury misconduct, newly discovered evidence, erroneous jury instructions, or a verdict that is against the weight of the evidence. Renewed motion for judgment as a matter of law. The post-trial version of the motion for directed verdict, renewing the argument that the evidence was legally insufficient to support the jury's verdict and asking the judge to enter judgment for the moving party. Motion to poll the jury. A motion requesting that after a verdict is announced, each juror be individually asked whether the verdict as stated is their own true verdict, used to verify the unanimity and voluntariness of the jury's decision. Motion for mistrial. A motion asking the judge to declare the current trial null and void due to a fundamental error, misconduct, or prejudicial event that has made it impossible for the jury to render a fair and impartial verdict, requiring the case to be retried before a new jury. Mistrial. A trial that is terminated before a verdict is reached due to a fundamental procedural error, juror misconduct, a hung jury, or other circumstances that make continuation impossible or unjust, typically resulting in the case being scheduled for retrial. Hung jury. A jury that is unable to reach a unanimous verdict after extended deliberation, resulting in a mistrial and allowing the prosecution or plaintiff to decide whether to retry the case before a new jury. Motion for continuance. A motion asking the court to postpone a scheduled hearing, trial date, or other court proceeding to a later date, supported by a showing of good cause such as the unavailability of a witness, incomplete discovery, or a scheduling conflict. Continuance. The postponement of a scheduled court proceeding granted by the judge, either upon motion of a party or on the court's own initiative, moving the proceeding to a future date to allow additional time for preparation or to address an unexpected development. Motion to vacate. A motion asking the court to set aside or nullify a previous judgment, order, or conviction, typically based on newly discovered evidence, fraud, clerical error, or a significant change in the law. Motion for reconsideration. A motion asking the court to re-examine and reverse a previous ruling in the same case, typically required to identify a specific legal error, newly available evidence, or an intervening change in controlling law that the court overlooked. Motion to stay. A motion asking the court to temporarily halt the enforcement of a judgment or the continuation of proceedings while a related matter, such as an appeal, is pending, preventing irreparable harm during the review process. Motion for relief from judgment. A motion under the rules of civil procedure asking the court to relieve a party from the effect of a final judgment or order based on grounds such as mistake, excusable neglect, newly discovered evidence, fraud, or changed circumstances. Motion to amend the judgment. A post-trial motion asking the court to correct or modify the terms of its judgment, such as the amount of damages awarded, to conform to the evidence presented at trial, or to correct a legal or clerical error.